Oh, this is going to have to be the thumbnail. This is going to have to be on the thumbnail. This is wild. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. We've had about 16-ish hours or so of live streaming over the last week because we've had several pages drop when it comes to Judge Hippler's orders for the motions to suppress for the defense team. Then we had the 175-page transcript drop from the closed session that happened on Thursday, January the 23rd. We went over that live as well. Now, for my members, there is a Google Drive link in the members only tab of the community section for posting. Only members are allowed, and I have to approve the access once you click on the link and it sends me a notification. So again, that's members only. I'm going to be adding more things to that, notes that I take whenever I'm listening to videos that I end up doing reviews for, or just different things, just different little extras that I can finally give you guys. I'll be going in and doing highlight videos on all the newest information as well, because that was a lot of hours of live and ain't nobody got time to sit there and listen to all of that. Yesterday, we noticed in the case summary that there were some motions in limine finally filed by the state. We've been waiting for them to start filing these for a long time. They have been threatening to file this to make the IGG information inadmissible in court regardless of anything for a long time. That's why it was always hysterical to me, hilarious actually, that people were throwing a big old fit about the defense wanting to throw it out for what it seems like very legitimate reasons. Judge Hippler is not stating that all of these things did not happen, that the defense is claiming happened here. He's claiming that it's not constitutionally relevant. That's what he's claiming. Honestly, I feel like he's full of it, but that's not what this video is for. Anyway, the defense had been wanting to have it suppressed, and people were all angry about it, but the state has been claiming that they were going to be filing for it to become admissible anyway from the very beginning, and I found that the energies for that should match. They really should if you really think about it. But whenever we now have these documents from the state, which one are we missing? We're missing the one for the IGG. Now, I don't know if it just hasn't posted yet. Maybe by the time I am done recording and editing and getting this video out, it will have been an edited in edition because suddenly the IGG motion of limine has now been filed and it is public. But we don't have that in this. We have different ones, and let's go ahead and start going through them. See? Nothing for the IGG. We have one for admissibility of demonstrative exhibits and memorandum in support, and the title of it doesn't actually cut off the way that I thought it cut off. I thought we'd get a little bit more information on that, but that's the title of it. I opened it earlier. That's the title of it. Then we have one for alibi, one for the alternative perpetrator evidence, which is, again, the same kind of crap that we saw in the Delphi case. Nothing about the Odinism, about Ron Logan, about Keegan Kline, about none of those things that actually have some backing. None of those things could be talked about. Then we also have the neuropsychological and psychiatric evidence. That one's interesting, but it's not really maybe as interesting as I thought it originally could be interesting, and we'll get to that in a minute. But what we also have is something from the defense. They're actually asking to exceed the page limit for their own motion in limine. Now, again, these documents from the defense are not out yet. It looks like they are still being written because they're asking for more pages. He does grant this, but he tells them no more than 20. So whenever that one drops, depending on the day and what I'm doing, we might go live for that one. 20 pages is honestly a breeze compared to what we've been doing lately. But they plan on filing their own motions in limine for improperly disclosed expert testimony and for Riley Nowlin and the reference to touch and contact DNA, which that's interesting because that's like what this is apparently, right? Like it's touch DNA, it's transfer DNA, it's boo-boo. So I don't know why they're wanting to motion in limine that. I guess we're going to just hopefully get more information in the document for that. But then also for the witness identification of bushy eyebrows. But it's actually kind of interesting that the defense wants that taken out because Dylan doesn't recognize Bryan Kohberger's bushy old eyebrows. So you'd think that that would be like an up for the defense, that they would want that in there, that the very person who the police got that description from Don't recognize the eyebrows of Kohberger. Do not recognize the eyebrows of the suspect. That should be super important. That has been like a constant apparently in all of her interviews, apparently. It also says there's going to be a motion in limine for conditions as aggravator. Again, we'll get more information on the details of those once that actually drops, hopefully in the next day or so. Okay, so here's this first one. This is the state's motion in limine regarding admissibility of demonstrative exhibits and memorandum in support. Comes now the state of Idaho by and through the Latell County prosecuting attorney and respectfully moves this court for a pre-trial order regarding the admissibility of demonstrative exhibits. Specifically, the state will seek to introduce a three-dimensional model of 1122 King Road residence for demonstrative purposes to aid the witnesses in their testimony. The state further submits the following memorandum in support of its request. Okay, but a motion in limine is like to make something inadmissible. From all the things that I have read, this sounds like they're wanting to add it, which we already knew this was going to happen. We've actually had like really big arguments about how they could sit there and talk about how they were ready for trial October of what was it, 23? And it wasn't until after the speedy trial stuff was waived that they were like, oh, finally, we actually have time to go back in and do the scans correctly because, we didn't actually get everything the first time. Okay, let's read the standard of admissibility because right now I am a little bit confused. It sounds like they're wanting to put this in because it says the state will seek to introduce this 3D model of King Road. And again, limine is supposed to be removing, making it inadmissible. The purpose of a motion in limine. In many court cases, there is information which, if heard by the jury, might unjustly prejudice the jury against the defendant. Once this type of information is heard by the jury, it cannot be unheard. Exactly, you can never unring the bell. So it is important for the party who might be harmed by such information to ensure it is kept from the jury. A motion in limine is usually filed before a jury is even selected, though it may be filed just before the jury is seated at trial. Motions in limine generally question the admissibility of certain evidence, though they may also question the qualification of an expert witness. The purpose of a motion in limine is to determine whether certain items of evidence are irrelevant or unfairly prejudicial. Evidence that the judge determines is inadmissible must not make its way by any means to the jury. This includes directly offering the evidence as proof, making statements alluding to the evidence, or asking questions regarding the evidence within the hearing of a jury. Relevant evidence is that which tends to prove an important fact to the case. While it would seem that any evidence that has to do with any fact of the case should be heard by the jury, there may be certain evidence that would confuse the issues, mislead the jury, or create unfair prejudice. In this circumstance, a motion in limine may be used to ask the judge to determine whether the value of that evidence is outweighed by its potential to have a harmful effect. See, so that's why I'm a tad bit confuzzled as for why this is stating the state is seeking to introduce this. And again, this is me reacting to it. I don't know what the hell the rest of this stuff says. It might make sense in a second, but this right here sounds like it's flip-flopped. I don't understand. Standard of admissibility. Trial courts are endowed with discretion over the use of demonstrative exhibits during the trial. And then it cites State versus Weigel from Idaho in 2019, State versus Pangborn from Nebraska in 2013. The Idaho Court of Appeals held an exhibit is properly admissible for demonstrative purposes when the exhibit supplements the testimony of witnesses or assets the jury in obtaining a better understanding of the facts at issue. And then it cites Masters versus Dewey from Idaho in 1985. The Idaho Supreme Court held, it is established that the use of exhibits by a testifying witness in order to supplement or illustrate events is proper insofar as the differences between the events depicted and the events observed are explained by the witness, and the exhibit is not deceptive. I'm sorry, but anything that is 3D rendered and can be literally manipulated, I don't trust at all. I don't give a damn. No 3D, VR, I don't care. No, I do not care. State versus Hall, Idaho, 2018, another citation. The appropriate test is Idaho Rule of Evidence 403, balancing test of probative value against the danger of unfair prejudice, distraction, confusion of the issues, and waste of time. A diagram offered for demonstrative purposes need only be relevant to illustrate a witness's testimony. It does not need to be precisely accurate, i.e., not to scale. Excuse me. How many freaking but thousands of dollars were spent on those scans? It better be to the umpteenth centimeter. Okay, what are you freaking serious right now? More recently, the Idaho Supreme Court has agreed in State versus Roman Lopez, finding the use of demonstrative exhibits at trial appropriate to aid the understanding of testimony that may be otherwise difficult, to comprehend through words or gestures along. And then it cites this and states McCormick explains that demonstrative or illustrative aids may be created outside of court or by the witness on the stand and are generally admissible, subject to an unfair prejudice objection, under the theory that they illustrate and explain live testimony of what the witness is trying to describe. I mean, I had no doubt whatsoever that they were going to end up having some sort of 3D rendering of the house up as Dylan was describing her getting up and opening her door, and whenever they were sitting there trying to describe who was in what room, and whenever the DoorDash comes and there's somebody that goes and answers the door. I expected all of that. This makes total sense to me. In other words, when the drawing is admitted for demonstrative or illustrative purposes, the witness testimony is the evidence, and the map or diagram is merely an aid to its understanding. Thus, the drawing is not hearsay because it is not an out-of-court statement admitted to establish a particular fact. Okay. Now we're getting into the reason for this, because I'm color me confused at this moment in time still, and we're on page 3, okay? In this case, the state anticipates introducing a 3-dimensional model of the 1122 King Road residence, and it's apparently already an attached exhibit at trial. This model will consist of 3 levels, which can be removed by level to show the interior layout of the residence. It should be extremely detailed. The interior layout will depict wall and door placements, no furniture or human depictions. So if you're not going to use it to show like a body laying in the beds and the way, oh my gosh, so it's useless. Y'all did all of this for nothing? I guess maybe they couldn't put human depictions because they didn't scan it with the humans in it, but I thought the whole point of the 3D model was for them to be able to actually go in and put the humans into places as they showed it. Okay. The model will be placed on a rolling table for portability within the courtroom. Holy crap, it's not. Okay, so obviously I really thought 3-dimensional model meant it was going to be some sort of virtual thing. They're talking about they built a dollhouse. The model will be placed on a rolling table for portability within the courtroom. Are we like back into Kill a Mockingbird days? Are they for real? I.e., can be placed out of the way when not in use. I really thought we were going to be high tech here. Like, are we for real? I am disgusted and like, what? This model is being constructed by the Federal Bureau of Investigation based on depictions, documentation, and measurements taken at the scene prior to demolition of the 1122 King Road residence. The primary purpose of this model is to aid the jury in having a better understanding of the layout of the residence, which is unconventional, and to illustrate where certain events occurred, within the residence. The model will aid certain witnesses, i.e., law enforcement, surviving roommates, individuals responding to the crime scene, and crime scene analysts in demonstrating the location of the victims, location of witnesses, location of items of evidence, items related to their testimony, path of travel, etc. The state anticipates laying the proper foundation to establish the model accurately reflects the layout of 1122 King Road residence. The model passes the IRE 403 balancing test as the value in facilitating the jury in visually understanding where facts in issue occurred at the crime scene far outweighs any danger to unfair prejudice, distraction, confusion of the issue, or waste of time. This model will merely aid witnesses' testimony and is not being introduced to establish a certain fact in issue, therefore is not hearsay or not being offered for the truth of the matter asserted. The state requests the court issue an order allowing the state to use the 3-dimensional model of 1122 King Road residence, finding that the model is relevant in order to aid witness in their testimony. I mean, I agree with that. So maybe I guess it would make sense for them to be able, wow. Guys, this is horrid. Look at this disaster. My kid, my 6-year-old builds better crap than this in every video game he's ever played ever. It's 35 inches this way, 52 inches high, 48 inches this way. Are they for real? They spent all that extra money on those Faro scanners to do this? Oh, this is going to have to be the thumbnail. This is going to have to be on the thumbnail. This is wild. But I guess it would make sense that they also want things to be allowed in that maybe are not actual evidence things. Stuff like this that is for reference, but that's not actual evidence. So I guess it does make sense, but I really was just under the understanding because, again, layperson, okay, my little degree is in the forensic science portion of this entire thing, okay, and I didn't get to finish the whole damn thing, okay. I've got one portion of it and then got halfway through the second portion of it, so I don't have all of the answers, nor does everything make a lot of sense to me. I come out here trying to figure things out just like you guys do. I really did think that it just meant that they were trying to make everything completely not admissible whatsoever. But I guess it could also mean implementing things in that are not technically evidence based in order to aid the testimony. It does make sense. I guess this is where I'm going to go ahead and end this one. I'm going to leave me going over the titles of all of the other ones in this one and just do them in a separate one. The one for the alibi is like 14 pages. And so what I'll probably end up doing is going back through and digging up the alibi information that we do have directly from the defense while we're going over the motion of limine for the alibi so that we can compare what's happening, what's being said, all of the things. But right now, let me know how you guys are feeling about this freaking dollhouse. Again, the Faro scanning was thousands and thousands of dollars, and they did it in 2 different sessions. And as far as I can remember, and again, my memory might not be completely 100%, but from what I can remember, there was like a device upgrade in between the first session of Faro scanning and then after the preliminary was canceled out and they did the second round of Faro scanning. And normally with updates and upgrades come higher prices. So there was a lot of money spent. A lot of money spent just for them to put together some damn Lego house. I really did think there was going to be some sort of virtual thing happening, whether it be like holographic in the middle of the freaking courtroom or they put on like VR and walk through it as it's being discussed and talked about. Like, I really thought with the way that especially Steve Goncalves has been coming out and talking about how high tech this case is supposed to be and all this digital data and blah, blah, blah. Like, they really made it sound like the way that the house was going to be represented was going to be really, we were going to be totally okay with the fact that the house was gone because of how well this was all going to be done. That's the impression that they gave. And instead we have this. Like, this is worse, honestly, than the way that I thought the virtual thing was. Because with the virtual thing, you still can't replace the real thing. You can't replace being where Dylan was in her room and hearing all the things that she's claiming to have heard from the areas in which she's claiming to have heard them. You can't be standing where the camera is and listening to things being done inside the home and get an idea about how it actually sounds. Like, the way that the audio works, the way that so many different things work in this house matter, especially when it comes to the way that the jury is going to be looking at things. Just the latent shoe print itself. If you go by the way that the probable cause has it, it's as if it's going in a direction that would lead to the sliding door where they are now trying to claim that the assailant left. But what they're not telling you is that this isn't in a direction really leading too much of anywhere if you really think about it, because it's in the threshold of Dylan's door. As in, the door would have had to have been open in order for the latent shoe print to be placed where it actually is in the crime scene. And it's not like she ever claimed that the assailant like rushed her or anything like that to where this person would have walked towards her to put the footprint in that area where it would be in the threshold, literally in the floor area that would be touching the door as the door would be being shut. That doesn't add up to the story that they've been telling us the entire time. I wish they had some more information on this latent shoe print, because I'm not understanding the reasoning for it to be being there to begin with. But we could go on and on and on about the one-legged pirate that's apparently hopping around 1122 King Road. But like I said, for now, I'm going to go ahead and end this one. I'm going to do it's around 5:30, and I just finished editing, and I wanted to make sure that there wasn't anything else besides what I told you guys at the beginning of this. Because like I said, I plan on recording the alibi document tonight, and it's about 14 pages. So I just wanted to make sure before I upload this. And I'm glad that I looked, because as you can see, there's nothing document-wise to look at, but we've got a lot of stuff going on the case summary. The case summary is wild. Okay, so the last thing that we have right now that we can look at is actually this one granting the page limits. What we actually have here is the state's motion of limine for the IGG. It has officially landed. There's also a motion in limine for the 911 call. There's also a motion in limine for the immediate family members in the courtroom that the state has filed. That's going to be really interesting to read. Are they trying to get people to not be able to show up in court? Okay, that's going to be really insane. And then they have some stuff that's getting sealed because of that. Okay, so then there's also one for improper death penalty comments. Is that for the Goncalves family? Oh, wow. Okay, so now we also have one for text messages and testimony. Whose testimony? Whose testimony? Now we have one for the AT&T timing advance records. There is sealed stuff also being submitted. There's something for self-authentication. I don't know what that's about. Then there's one for inflammatory evidence, vague and undisclosed expert testimony, use of the term murder, using the term psychopath, sociopath. Then we have the one that we were just discussing, the Ryland Nolan and the references to touch and contact. Then we have the witness identification by bushy eyebrow, and the unnoticed 404B evidence, Amazon click activity evidence, improper expert testimony from middlemen. Then we have another motion of limine to exclude the IGG. I wonder if that's something from the defense. Then one for the make and model of the suspect vehicle, conditions as aggravator. And then we have some more information being filed under seal. This is like all, I guess, like exhibits and documentation supporting their orders. Inconclusive data and motion in limine for statistical analysis under seal. More inconclusive data, statistical analysis, stipulated agreement of the parties regarding investigators in the courtroom during trial, like who's going to actually be allowed inside. They already sound like they're trying to like lock down the courtroom. Like for real lock down the courtroom? Parties not to mention 2014 cell phone incident during trial. 2014 cell phone incident. Is that the one that we heard rumor about where he stole his sister's phone and his dad called the cops on him? I don't know if that's the one. I just know that it happened whenever he was like a teenager. He was apparently a minor, and there was like no police record that could be found because he was a minor. Is that the one they're talking about? Is that the only thing they have? Holy crap. Autism spectrum disorder. Guys, I've been telling y'all from the freaking beginning, I felt like Kohberger was autistic. You can go back to my very like beginning videos. I said that. But this is interesting to see because we've talked about the possible autism spectrum before. We are going to be extremely, extremely busy, like for a while. I am wow at these titles. Wow, this is going to be so much information. I hope you guys are ready because you know we're going to go through all of it. Literally all of it. Even if we have to do 2-hour lives every day to try to get through it, just so that we don't go way too long at a time, but also don't take too long. Like, tell me what y'all think about doing that. If all this stuff ends up dropping at about the same time, which it sure the frick seems like it's going to, we could schedule out like 2-hour blocks a day to go through all of these until we get caught up. I'm down for that if that's what it takes. Because it'll take a hell of a lot less time for us to do it live in 2-hour blocks of time than it will for me to make time to record and then edit and then download and upload and like all the things. And that way we can discuss and look up stuff in real time and bring up documents and compare and contrast things and do things that way. Dang, this is going to be a lot of information. Let me know how you guys are feeling so far right now. It looks like a lot because it is a lot, but let's just breathe and just get ready for whatever's coming, because what have we always said? We're going to follow the evidence no matter where the evidence leads us, because it's facts over feelings and facts only. If they've got the right guy, which I doubt, then they've got to prove it. They've got to prove it. And if they've got the wrong guy, then we have to continue to bring out the facts and prove where they've lied and proved where they've broken the law so that justice actually happens here. If the wrong guy gets convicted, that's not justice for the 4 that lost their lives. That is not justice for Xana and Ethan and their lost love story. That is not justice for Maddie and Kaylee, who grew up literally attached at the hip like they were the sisters, okay? It's not justice for them. Or the ones who are actually missing and are in sorrow over missing them. It's not. This has to be done correctly. It's been a lot, but let's go back to the main subject of this video, and that's talking shit about this pathetic dollhouse looking thing. Okay, let me know how you guys are feeling down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already, and please don't forget to make sure that that notification bell is set to all, especially for all this stuff that's coming up, okay? Please, please, for the sake of everything that is trying to find truth and justice in this insane situation, have your notification bell set to all. I post a lot of stuff in the community tab whenever I see stuff in documents, whenever things need to be questioned, whenever things need to be called out. Hit it to all, guys. I promise you it's worth it. See y'all.